which was in my favor, and which also was directing the police to give security to evict the member from my house.
Was this decision in your favor, given the publicity that for 5 years the world kept being told about the bad Linturi?
It was not.
It was not publicized. And why have you placed the document at page 320 before the committee?
There is also another document to prove to the committee. Despite her losing those cases, she went for appeal, and the appeal was also dismissed by the court.
So she lost, she appealed, but she still lost.
Yes.
Was that victory on your part, given the publicity, to erase the image the world has been fed for years and years of Linturi, the bad guy?
It was never done, contrary to what had been published before, as a man who depends on a woman for livelihood, who is kept.
Do you actually depend on women for livelihood, Honorable Linturi?
I maintain them.
Let's go to the document at page 337, sir.
Yes, 337.
Why have you placed this document before the Honorable Select Committee?
Your Honor, is also to demonstrate that despite the appeal that she made, the court also ruled again in my favor.
So when the court ruled in your favor, was this victory on your part ever publicized the way the allegations against you have been publicized for 5 years?
It was not. And members of the committee, not only did I get these federal court orders, but I also got the costs which I have never asked for. I think it's important.
So, Honorable Linturi, we have gone through decision after decision after decision, through and through and through, and they are all in your favor. Correct or incorrect?
Correct.
Are these decisions made by one judge?
No.
Are they decisions made by one magistrate?
No.
Are they decisions made by one court?
No.
Are they decisions made by some clique of judges and magistrates?
No, no.
As a matter of fact, are these decisions from the same court station?
No.
So you will agree that these are well-spread decisions from various judges, various courts, various magistrates?
Yes.
Let's go to the document at page 361.
361?
Yes. Why have you placed this document before the Honorable Committee, sir?
I have placed this document before the committee to demonstrate that the alleged contract that gives leeway or room for Africa, Western Capital African Dynamite, to use the NSPB infrastructure to display its GPC and diatomaceous material was signed or executed long before I assumed the office of Cabinet Secretary.
What is the date given on the face of the document?
That the 1st March 2022.
Were you the Cabinet Secretary?
I was not.
On that date?
No.
To the best of your knowledge, sir, can you be dismissed from office for agreement signed before you took up that office?
If that was to happen, it would be very unfair. And by the way, even the current administration are not come to office. It's not only Mithika, Linturi, CS. Even the current administration.
So the entire Kenya Kwanza administration has not even come to office?
Yes.
You are accused, sir, through this document, of lying that this agreement was for a soil conditioner and not fertilizer. Does the word fertilizer appear anywhere in this agreement?
I've not seen any at all, and it doesn't.
How many pages does this document have?
I think 5.
5 pages?
No,
and
6.
6.
And then, yeah,
and across all of them, the word fertilizer or its equivalent doesn't appear anywhere.
Yes.
What do you make then of the accusation against you that you lied to the departmental committee that this was an agreement for a soil conditioner?
I think it's the mover who is trying to mislead the committee and not me. Who is that?
It's the mover who is trying to mislead the committee, not you. Let's go to page 367. L together with 368. Why have you placed those documents before the committee?
I have this document before the committee to demonstrate that if I really want the NSPB Chief Executive Officer to exercise caution in the receipt of fertilizer, because I really wanted them to make sure that whoever had won that contract, because I got to know about it when it was over, that all the suppliers were able to file with the institution the fertilizer chemical composition of what they had won in that particular tender, so that we will be able to really to confirm before delivery that farmers will get the right fertilizer to suit their planting requirements.
Please read to the committee the parts that are highlighted in that letter.
There is therefore need to ascertain the quality and composition of fertilizers before delivery to ensure that farmers get the right fertilizer to suit their planting requirements and boost agricultural productivity. And therefore, the purpose of this letter is to ask the suppliers to confirm in writing the fertilizer chemical composition to supply before delivery. This was a
What is the date of this letter, sir?
20th in December 2023.
That was long before the problem the committee is now seized with, isn't it?
Yes.
Is the content of that letter consistent with the allegation of a fraudulent minister who is approving the procurement of fake fertilizer?
It is not consistent.
Is it consistent with the narrative of an incompetent minister who has no clue what is happening in the ministry they have?
It's not.
Is it consistent with the allegation as to the existence of a policy to procure fake fertilizer?
It is inconsistent.
It is inconsistent.
Yeah.
Let's go to 369. You noting the guidance already given by the committee. Why have you placed that document before the committee?
Just like I said, this is what the gossip within the Star newspaper that spreads out stories trying to say that within sources close to power and intimated that one of the members from the Rift Valley and choreographed the fake fertilizer to have and if Irene, her ex-boyfriend, CS fired.
Let's go to the document at 371. Why have you placed, what is it and why have you placed it before this committee?
371 is the Evidence Act,
yes,
which guides procedure of collection of evidence.
And what is your understanding of the highlighted part?
All evidence must be direct. All evidence must, in all cases, be direct evidence. And the purposes of that, subsection 1, direct evidence means with reference to a fact which could be seen, the evidence of a witness who says he saw it. With the reference to a fact which could be heard, the evidence of a witness who says he heard it. And the reference to a fact which could be perceived by any other sense or any other manner, the evidence of a witness who says he perceived it by that sense or in that manner.
So this provision of the law, sir, says any accusation against you must be proved by a witness who saw it with their eyes, who heard it with their ears, who touched it with their fingers, or perceived it with any of the other 5 senses. Have you seen any such witness in the proceedings against you?
I have not.
How about the document at page 373? Why have you placed it before the committee?
This is a case by the House of Lords of England on, and is on an appeal from the Supreme Court, and it was on, I think, on Hoja's evidence, which the court held that the ones spoken by the woman did not form part of the res gestae and were not therefore accepted from the fundamental rule against.
You say this is a decision of the House of Lords, and you're a lawyer. What type of court is this called the House of Lords?
This is the highest court in England, I think.
It is the highest court in England and Wales. Is it a respected court?
It is.
Is our legal system based on the legal system of England and Wales?
Yes, we remember we are in British colony.
As a matter of fact, Honorable Linturi, is this decision the highest possible judicial opinion you can get on Section 63, which you've just read about direct evidence?
Yes.
Lastly, can you read from that decision at page 379 what the House of Lords held?
This is what the House of Lords had to say. The rule against the admission of Hoja's evidence is fundamental. It is not the best evidence, and it is not delivered on oath. The truthfulness and accuracy of the person whose words are spoken to by another witness cannot be tested by cross-examination, and the light which his demeanor would draw on his testimony is lost.
Honorable Chair, I suggest we could leave for lunch at this point. Then when we resume, my learned friend, Mr. Boniface Mawira, will take the remaining part of the examination in chief.
Thank you. We will do exactly that, but I will release all the other parties apart from the select committee so that we can consult for 2 minutes.